In this video, I'll be discussing the Maritime Labour Convention, or the convention known as MLC 2006. Now, Maritime Labour Convention is a comprehensive international labour convention that was adopted by the International Labour Conference of the International Labour Organization, or ILO, at Geneva in Switzerland. The convention basically sets out the seafarers' rights to decent conditions of work and health to create conditions of fair competition for seafarers. It is intended to be globally applicable, easily understandable, and readily updatable and uniformly enforced. This video may be a bit long, so you can watch it in stages, but I want you to have a good understanding of this convention by the time you finish watching this video. So please stay patient, otherwise watch it in stages. Maritime Labour Convention, or MLC, that I'll be calling it MLC from now, was designed to become a global legal instrument that will be the fourth pillar of the international regulatory regime for quality shipping, along with the STCW Convention, SOLAS Convention, and MARPOL Convention. The MLC basically contains a comprehensive set of global standards based on those that are already found in the maritime labor instruments, that is individual ILO conventions. Now, previously there were 69 ILO instruments which have all been now included under the common umbrella of the MLC, or the Maritime Labour Convention. The convention basically consolidates and revises the existing international law on all the individual 69 instruments. A few examples of the individual 69 instruments are listed over here. So you can see here that previously the states or the ship owners had to comply with the individual ILO conventions. The numbers are listed in the brackets and the name of the conventions are seen on the screen as well. But now all these conventions have been included under the MLC. The reason for so is that the aim of the AMC was to ensure a comprehensive worldwide protection of the rights of seafarers, and that is why the convention is sometimes called the Seafarers' Bill of Rights. And the convention also wanted to establish a level playing field for countries and ship owners committed to providing decent working and living conditions for seafarers and protect them from unfair competition on the part of substandard ships. Previously, ship owners and states could get away by ratifying individual conventions and complying with only selected conventions. But then it was decided that all these conventions, if put under the Maritime Labour Convention, then the states would have to comply with the overall, and hence all the individual 69 individual ILO conventions, so that seafarers' rights could be protected. The ILO Convention, or the Maritime Labour Convention rather, to come into force required ratification by 30 countries that represented at least 33% of the world shipping. By 2009, it had already been ratified by the 4 major flag states that represent more than 40% of the world tonnage, that is Panama, Liberia, Bahamas and Marshall Islands. But because it was not fulfilling the second need of being ratified by 30 countries, it took some time to come into force. However, it came into force on 20th of August 2013. Australia, for example, had ratified the convention on 21st December 2011 itself. As of 2019, the convention has been ratified by 88 states that represent 93% of global shipping. If you look on your screens, then you can see the countries highlighted in purple represent the countries where the convention is already in force. The countries that are colored in pink are parties where convention is not in force. There are some countries, maybe not very clear on your screens, which were in green, which basically indicated that the instrument for ratification of the convention has been submitted but not yet registered. These will be updated in due course of time, of course. So keep yourself updated. So like I said, the Maritime Labour Convention basically consolidated all the previous 69 instruments or ILO instruments. This also made it easy for the IMO to update all these 69 conventions under the common umbrella of the Maritime Labour Convention. Otherwise, if individual conventions had to be updated, it took more time for the IMO to update these conventions, because updating conventions is a time-consuming process. It has to go through a lot of procedures. But putting all these 69 conventions under one umbrella makes it easy for the convention to be updated and hence to protect the seafarer's right. So if I can summarize the conventions requirement, the countries that have ratified Maritime Labour Convention 2006 now do not need to comply with the previous individual ILO conventions. However, countries that have not ratified the MLC 2006 will or continue with the individual ILO conventions that have been ratified. However, as I will discuss later on in the slide, we will talk about the no favorable treatment principle, which is making countries now difficult to not ratify this convention and keep their ships sailing. But we'll talk about that later on. In Australia, for example, the Australia's new Navigation Act, which was introduced in 2012 and commenced on 1st July 2013, contains the new provisions that point directly to the implementation of the MLC. A new marine order titled Marine Order 11, Living and Working Conditions on Vessels, also came into operation on 1st July 2013. This marine order basically replaced Marine Order 10. Maritime Labour Convention 2006 is divided into two parts. The first part addresses those components of the MLC that commenced on 1st July 2013 and includes very specific regulations about accommodation and recreational requirements on board the ship, medical care and facilities, including access to dental care, access to and use of sanitary and laundry facilities, provision of free supplies of food and water and their storage and handling, the work agreements and their application, regulations governing rest break for seafarers, repatriation arrangements, the inspection regime and certification, as well as rights for young seafarers. The second part of the MLC contains regulations that came into effect on 20th August 2013 and contains policies regarding seafarer recruitment and placement, seafarer access to shore-based welfare, and the on-board and onshore complaints handling procedures. The Maritime Labour Convention is pretty much structured like the STCW Convention if you are familiar with it. Part A of the convention comprises of the standards, which are mandatory, and Part B of the convention comprises of guidelines that are only recommendatory. The MLC regulations and codes are basically focused in 5 main areas, which we'll discuss individually in the subsequent slides. The 5 main areas basically refer to the minimum requirements for seafarers to work on a ship, conditions of employment, accommodation, recreational facilities, food and catering, health protection, medical care, welfare and social security protection, and lastly, compliance and enforcement. Let's discuss now each of these individually. So you can see that the main areas in which the convention will improve significantly working and living conditions and employment rights of seafarers have been summarized on your screen here. If I can explain this simply, there are certain advantages for the Maritime Labour Convention. Especially for seafarers, it's a comprehensive set of basic maritime labour principles and clearly spells out in one place seafarers' basic employment rights. Seafarers are also better informed of their rights and of remedies available. There is improved enforcement of minimum working and living conditions. and right to make complaints both on board and ashore. For ship owners, it's a more level playing field to help ensure fair competition and to marginalize substandard operations. This makes the shipping industry more socially responsible and better protects the workforce and making it more efficient. It also helps ensure that ships are operated safely and securely with few problems and few delays in ports. New convention contains minimum standards that are well within the current industry practice and should easily be met by most ship owners. For governments, of course, this is simplification of reporting obligations, improved quality of shipping services, improved protection of the environment, and adding flexibility with firmness of rights and flexible as to how to be implemented, making the convention easier to ratify and implemented. Now let's discuss each of these individual areas that I have listed on your screens. Safe and secure workplace on ships, and I have summarized some of the requirements for the first part here. Basically talks about not allowing employment of persons under the age of 16, also not employing people who have not been certified as medically fit to perform their duties, or if they are not trained or certified as competent or otherwise qualified to perform their duties, and unless they have successfully completed training for personal safety on board ship. Seafarers shall also have access to an efficient, adequate and accountable system for finding employment on board ship without charge to the seafarer. At this point, I must tell you that although you may not have paid any charges to be employed on ship, there are many countries that were asking seafarers to paying large sums of money or even percentage of their wages before they were put on the ship. The seafarer recruitment and placement services operating in a member territory shall conform to the standards set out in this code. The second area where the MLC focuses on is fair terms of employment, where employment agreement guaranteeing decent on-board working and living conditions are to be signed by both the seafarer and the ship owner or the representative of the ship owner, that is a master. Monthly pay in full shall be ensured to seafarers, and seafarers should be able to transmit their earnings to their families. Minimum wage should be calculated by the prescribed formula taking into account cost of living, exchange rates, and updated at periodical meetings attended by the International Shipping Federation, International Trade Federation, and International Labour Organization. Rest hours, paid annual leave, shore leave, repatriation and compensation in case of illness, loss of employment arising from ship's loss, sufficient number of seafarers to be employed to run ships safely and efficiently should also be included. Member countries should have national policies that promote employment in the maritime sector. Hence, the safe manning certificate or the safe manning requirements also come under the Maritime Labour Convention. The third area focuses on decent working and living conditions on ships, where seafarers should have access to minimum room sizes, satisfactory heating, ventilation and sanitation facilities, lighting and hospital, consistent with promoting the seafarers' health and well-being. Seafarers should also have access to good quality food and drinking water provided under regulated hygienic conditions with appropriate quality, nutritional value, and quantity that adequately covers the requirements of the ship and takes into account the differing cultural and religious backgrounds. To ensure that seafarers who are engaged as ship's cooks are trained, qualified, and found competent for the position. I have been sailing even with people who were initially working as deck crew or engine crew, and they realized their life was very hard on ship and they shifted to the chief's cook's position without being adequately trained. But I am talking about way back when Maritime Labour Convention was not introduced. The fourth area that is being focused by the MLC is the rights to health protection, medical care and other social protection, some of which are coming under section B of the code, which are recommendatory only at this stage. So some of your companies may not be providing you with certain facilities. Another loophole in this convention is if the ship owners or the states can justify that they are providing certain aspects of some of the benefits, they don't have to provide with all the benefits here. So rights to health protection, medical care and other social protection shall include prompt and adequate medical care while working on board or shore facilities, material assistance and support from the ship owner with respect to financial consequences of sickness, injury or death, provision of occupational health and safety training and developing policies and programs to prevent accidents, injury and diseases on board, and seafarers' dependents to have access to social security protection, which include medical care, sickness benefit, unemployment benefit, old age benefit, employment injury benefit, family benefit, maternity benefit, invalidity benefit and survivor's benefit. But like I said before, this comes under Part B of the code and some of these facilities may not be provided to you on the ship. Finally, the compliance and enforcement requirements dictates that for ships over 500 gross tonnage on international voyages, which include a local voyages in another country by ship flagged by member, a Maritime Labour certificate and a declaration of Maritime Labour compliance will be required. Ships are required to be carrying these certificates to show that they comply with the Maritime Labour Convention. At this point of time, I must tell you that Maritime Labour Convention requires now ships to be inspected. Now, this inspection is very similar to port state or flag state inspection or ISM audits. So a port state officer or a flag state officer may come on board your ship, and if you are just focusing on basic safety and firefighting and not on the requirements of the MLC, it is quite possible that the surveyor may list your ship under a deficiency. So you have to ensure that your ships are clean, accommodation is clean, hospitals are clean, and that you're complying with this convention, because inspection or basic inspections like port state and flag state can also cover the compliance with Maritime Labour Convention. Hence, part of this inspection may also require you to produce the Maritime Labour certificate and declaration of Maritime Labour compliance certificate. Once the Maritime Labour Convention is in force, port state and flag states have the right to board your ships for inspections. For example, you can see based on the Paris Memorandum of Understanding Annual Report 2017, the MLC deficiencies, the top 5 deficiencies were related to seafarers' employment agreements, records of seafarers' daily works of work or rest which were not logged properly, electrical failures, cleanliness of engine room and sanitary facilities. Some of the detainable deficiencies included wages not being properly given to the seafarers, an employment agreement, calculation and payment of wages, cleanliness of engine room and sanitary facilities. Particularly if you are a senior officer on board, whether you are a master or a chief engineer, you should make a note of these, because it is your responsibility to ensure that your officers and crew comply with the convention. They have a good understanding of this convention and why it is important for you to keep your ships clean and comply with all the other requirements as well. Some of the publications are available to assist seafarers in the understanding of this convention. Such publications include guidelines for flag state inspections under the MLC and guidelines for port state control officers carrying out inspections under the MLC. There is also an ILO action plan which was delivered in partnership with the ITF, ISF and IMO, the goal of which was to ensure that convention not only comes into force as rapidly as possible, but also the various updates and exception clauses are understood by the parties concerned. Finally, on the last slide, I must talk about the no favorable treatment principle, which I mentioned some time back, and I told you how this principle is basically promoting more and more member states to become party to the Maritime Labour Convention. Basically, the no favorable treatment seeks to ensure a level playing field under which the ships of countries that have ratified the convention will not be placed at a competitive disadvantage as compared with ships flying the flag of countries that have not ratified the MLC. If I can explain this simply to you, so if you are sailing on a ship, the flag state of which has not ratified the convention, but you come into a country where the MLC has been ratified by the state, you would still have to comply with the provisions of the MLC. Hence, it's becoming more and more difficult for states to run ships without complying with this convention. Nearly 93% of the world's tonnage has ratified this convention, and hence it is becoming very challenging for ship owners to own ships and send them to countries where it has not been ratified. And this is basically done to promote this convention, and so that more and more parties now ratify it and seafarers' rights are protected at a global level. So I hope you understood the Maritime Labour Convention and you had a good understanding of it. If you still have any doubts or questions, please write in the comment section and let me know what you thought about this video. I'll see you soon with my next video. All the best guys, study hard and keep watching. Bye.